The House Committee on Election Integrity will come to order. Will the clerk please take the attendance?
Chair Smit.
Present.
Representatives Fox.
Present.
Outman.
Here.
Alexander.
Here.
Hoadley.
Here.
Pavlo.
Here.
Wooden. Holzar.
Here.
Song. Present. Madam Chair, you do have a quorum.
Representative Hoadley moves to adopt the minutes from December 9th. There being no objection, the motion prevails by unanimous consent. Good morning, everybody. Today we'll be taking up House Bill 5467. Since this is my bill, I will be turning things over to Majority Vice Chair Fox. The committee will go at ease at the call of the chair.
The committee will come back to order. Chair Smit, please begin when you are ready.
Well, thank you, Vice Chair Fox and fellow members of this committee. Today I'm testifying in support of my legislation, House Bill 5467, which would clarify the process for reprinting ballots when a county candidate position is suddenly unfilled due to death, unfitness, or disqualification. In August, this committee heard testimony on HB 4736, which was a bill we unanimously passed that would provide a process for replacing a county commissioner or county executive in the case of death. As I worked through this bill, 4736, it became apparent to me that the township officials do not currently have the clear directives on how to proceed once a new candidate is chosen. As the law is written right now, these officials are required to put the replacement candidate's name on the ballot, but there is no mention of what to do if this replacement happens after the ballots have already been printed, sent, and voting could be occurring. This gap in the election law could lead to a situation in which early voters may have filled out a ballot with the old candidate on it, while later voters will be filling out a ballot with the replacement candidate on it. In order to save election officials from administrative headaches and possible legal disputes, I have put together this trailer bill, 5467, which will require new ballots to be printed only if a candidate is replaced 55 days or more before the election. By creating this deadline, I consider the timelines for early and absentee voting, ensuring that the reprinting would happen before these processes are underway. We did also have a couple instances last election cycle with 2 different counties that were put in this position, so that was why we did House Bill 4736, and I believe this is an important step to follow that with just clarifying that and providing a clear statute for reprinting. It would make our elections fairer and replacement candidates and more straightforward for the local officials. These are just a few reasons why I'm asking for your support. I hope that the members of this committee can see, as I do, the necessity to streamline this process. Thank you for this opportunity to inform you all of this bill, and I welcome any questions that you may have.
Representative Outman.
Thank you, Chair Fox, and thank you, Representative Smith, for testifying on your bill. Now, you had mentioned that this is applying to candidates that, have deceased before the elections takes place. Can you refresh my memory of what happens when a candidate? Well, let me just give you the example. So back in 2010, it was my first time voting. I just turned 18, and I voted for Brian Calley in the primary election. For the 33rd Senate District. Well, he was then tapped for lieutenant governor prior to the general election, and I can't remember how we replaced him during that process. Could you refresh my memory just a little bit?
So I don't really know how that would have been back in 2010 either. I don't know the timeline of when he would have already been on the ballot clearly and then was chosen for LG. So I'd have to look at that, but there is no clarification in the law, so maybe they did get rid of those ballots and then had to reprint them and resend them out. That actually happened in 2020 when I was a township clerk in my county, not my township, but another neighboring township. They had that, and they had to basically reprint all the ballots, and it does cause a lot of confusion. So my assumption is it would have been similar to that situation.
And it's not, that's okay. It's not really relevant to your bill. I was just kind of curious how that process played out because as I was reading this, it brought me back to 2010, during that election. So I was just curious, like, how did we replace him? But I will
Yeah.
do some digging on that and just see if I can get some clarification. But I do appreciate your legislation and appreciate you testifying on it.
You're welcome.
Representative Zong.
Thank you, Chair, and thank you, Representative, for your testimony. I know that it takes time to print ballots, but I was just wondering why the 55 days was chosen and what happens in the case if there is a death or a disqualification that is a lot closer to the election.
So the 55 days came from just talking and discussions with the clerks. They felt that that was a reasonable time frame. You can't really, there's always going to be a time period that could happen where you just wouldn't simply have enough time to reprint ballots and get them all out. So 55 days was a reasonable, we thought, line, and also working with the clerks, that's what they wanted. So the clerks are also supportive of this, and we were working with MDOS as well, which they are supportive.
All right, thank you. Thank you, Chair.
Okay. Any other questions? So we now have additional testimony via video from Lisa Brown, the Michigan Association of County Clerks.
Thank you. Good morning. Yes, I'm Lisa Brown, the Oakland County Clerk, Register of Deeds, here in support of House Bill 5467 on behalf of the Michigan Association of County Clerks. In July 2024, we had a candidate for state representative who unfortunately passed away suddenly in July. Ballots had already been printed, public accuracy tests were already scheduled, absentee ballots had already been returned, ballots for early voting were ready to go. Currently, the law states that even if a candidate dies on election day, we have to reprint. We need to program proof. Somebody was asking why 55 days. I'm going to tell you why. We need to program the election. We need to proof the ballots. We need to test the ballots. We need to print the ballots. This bill gives us the 55 days gives us the time we need to do that and still meet the statutory 45-day delivery date, as well as the 40-day constitutional right to voters to have to receive a ballot. So when that happened in 2024, Genesee County and Oakland County were sued by the political party, and the court actually sided with us, the clerks, recognizing that it was impossible for us to implement and follow to print and do everything that we need to with the other requirements for testing and all of that. So, and to answer somebody's question, so if someone dies after that 55 days, there can always be a write-in candidate, and if a death occurs after the write-in deadline passes, which is like 11 days before election day, the law states 168.737A that no write-in declaration is required and all write-ins will count. So that's already in law. There's already like a fail-safe for that. So, and going back to the LG question, I know when I was picked as LG in 2014, that was well before the filing deadline. So I'm guessing that was, I can't remember in 2010, I was in the House then, but I don't think that the filing deadline had passed yet. So, and again, the election laws were different in 2010 than they are now. We've had a lot of changes, but I'm happy to answer any questions. But I do want to thank Madam Chair for introducing this bill, in regards to our request and giving it a hearing, and I hope that this passes through quickly.
Okay, thank you very much for your testimony. Do we have any questions? Okay, there being no questions, are we ready to move on to the next introduction of the next bill, House Bill number 5468?
Thank you. This is a pretty straightforward bill. It would clarify the information that must appear on a candidate's filing affidavit and require congressional candidates to indicate whether they are residents of the district that they are seeking to represent. In recent years, as many of you have seen, and maybe even experienced yourself, there has been a lot of threats and safety concern involving candidates and elected officials. Policymakers here right in Michigan, ourselves and elsewhere, have explored additional protections. For example, the Judicial Protection Act and the Elected Officials Protection Act are efforts made in this session to safeguard personal information. So the thought behind this was just removing the street address on nominating petitions. They would still have to say the county that they reside in, as well as providing a website if they have. So that's the change that this bill would make, as well as also, as I stated before, indicating whether, if they're in a congressional district, to indicate whether they are residents of that district that they're seeking to represent. You do not have to verify that right now. I mean, congressional resident or candidates can file and run in not even a district that they would be living in and representing. So because this nominating petitions are public documents, listing the candidate's street address may unnecessarily expose them to risk. There's also a broader need to standardize information across that nominating petitions. So that's the crux of this bill. It's pretty straightforward, and I, again, would welcome any questions that any members may have.
Okay, we have a question from Representative Golazar.
Thank you, Mr. Chair, and thank you for your testimony. Even if a candidate's street address is no longer on the nominating petition, doesn't it still appear on their affidavit of identity?
Yes, it is still on there. This would just be for nominating petitions, so hopefully these are the ones that get circulated around for signatures and people have easier access to see that street address. So the thought behind this was it would reduce that exposure of a street address. But yes, it will still be on the affidavit of identity.
Okay, I was just wondering. Thank
Yep.
you.
And I will just ask a question. So is this focused on federal elections?
State and federal.
State and
Any
federal.
elections that would involve,
Okay.
races here in Michigan.
So long story short, a person, and I'm trying to make straight the verbiage here, does a person have to live within their district in order to get elected? That's the fuzziness I'm having from what I was just reading through here.
So there's no residency requirement requiring a candidate to live in the congressional district. State, you must, but congressional, there's
Okay.
no residency requirement. So what this would do was just, they would have to indicate if they are a resident of the district that they are going to be representing.
Okay. And then I'll take it one step further. Can they move in the day before and then get elected? I mean, how long do they have to live in a district in order to get elected in a district? I'm talking state especially.
That doesn't cover what this bill is.
Okay.
So, I mean,
Yeah. Okay. That's just a fuzziness that I keep on bouncing up against, with various conversations, so.
I mean, I would imagine by the time that they're living there, when they get sworn in to office, would be,
Okay.
even if it was the day before, that they just moved in.
Okay. Very good. We do have a couple more questions. Representative Zong.
Thank you, Chair. Thank you for your testimony. I think this is a great bill. Privacy for electeds is very important to me. And I will say that I have a congressperson who ran in my district that doesn't live in the district. But if the intent is to protect elected officials and candidates running, I think this bill stops short because of that affidavit of identity that still we still have to put our address there. And there's not a lot of clarification. I've seen candidates even putting P.O. boxes on that affidavit of identity. There's a list of candidates on the Secretary of State's website with those addresses. And so I would love to see more protections for candidates and not necessarily this one, because as you said, being a congressional candidate, you're not required to live in the district, so that doesn't address the underlying issue, which is the privacy and the protection of us as candidates.
Okay.
Thank you. We can certainly talk further about that and consider that.
Okay, thank you. And Representative Outman.
Thanks, Chair, again. So kind of piggybacking off of Representative Zong's question, are the affidavit of identities, are those public documents?
Yes, they
So-
can be FOIA'd.
Okay, so what was the rationale for not striking the addresses and personal information from the affidavit identity?
I guess just to verify that they are indeed living where they do live, to have a physical address. So you're still maintaining that piece of it, but yet when it comes to the petitions that get circulated around publicly, I mean, yes, anybody could always FOIA that information and get that, but hopefully, I'm not sure. This would be something to maybe look into with the whole Elected Protection Act that we just passed.
It
If
just-
that,
And I
then
think
to having to,
I think we probably should. It doesn't really make sense to me if we're going to strike that personal information from the nominating and leave it on another public document. It's like, well, we're, back home they would just say we're peeing in the wind. I mean, what are we doing there? Not that this isn't good legislation. I do agree with it. And if there's a psychopath out there, he's probably going to find your address one way or the other.
Yep.
I would caution against, my residents. We're firm believers in the Second Amendment, but if people are going to do harm, like I think they're going to
find a way, right?
They're probably
But
gonna
this
find
makes
a way.
it one less step easier to not have that just exposure be out there.
Do you
We're-
think? Do you think we should look at maybe?
I think we should definitely could take
Okay.
a look into considering that for the affidavit of identity.
Okay.
Because people, unless they FOIA that, they're not going to know.
Mm-hmm.
Or look, I mean,
Sure. Right. Okay. Well, let's continue that conversation.
Yep.
But again, very much appreciate this legislation.
Okay, are there any further questions? Okay, there being none, the committee will go at ease at the call of the chair.
thank you. The committee will come to order. I will read in the cards that we have. House Bill 5467, not wishing to speak, neutral. Bill Zagman with GCSI, Michigan Association of Municipal Clerks. Not wishing to speak, supports the bill. Michigan Association of County Clerks, Bill Zagman. Hold on. This one was the county, excuse me. Sorry about that. And supports the bills 5467 and 68. Melody Macy, promote the vote, not wishing to speak. Supports the bills, not wishing to speak. Sherry Ritchie, Pure Integrity, Michigan Elections. Representative Colazar moves to excuse Minority Vice Chair Wooden. There being no objection, the motion prevails by unanimous consent. And there being no further business before the committee will stand adjourned.